Remember the requisites for a valid incorporation by reference. Number 1, the paper or document to be incorporated by reference must already be in existence at the time of the execution of the will. Second, the will must clearly describe the paper or document, stating among other things the number of pages thereof. Third, it must be established by clear and satisfactory evidence as the paper or document referred to in the will. Fourth, ito ang controversial na source ng controversy. The paper or document must be signed by the testator and the witnesses on each and every page, except in the case of voluminous books of accounts and inventories. Because of the requirement that each page of the paper or document to be incorporated by reference must be signed by the testator and the witnesses, the question has arisen. Can there be incorporation by reference in a holographic will? Sabi ng iba, walang incorporation by reference in a holographic will because there are no witnesses in a holographic will. Sabi naman ng iba, paano kung may witness? It's possible for a holographic will to have witnesses. The presence of witnesses in a holographic will does not invalidate the will. That is simply considered as surplusage. Okay? Supposing there are witnesses. So according to them, if there are witnesses to a holographic will, then it's possible to incorporate by reference in that holographic will. Still others maintain, while it is possible to have incorporation by reference in a holographic will, it is necessary that the paper or document should also be entirely in the handwriting of the testator. Because if what is incorporated by reference in a holographic will is a paper or document which is not in the handwriting of the testator, upon incorporation, to borrow the language of Article 827, that paper or document will be taken as part of the will. Will be considered as part of the will. And if it is considered as part of the will, and yet it is not in the handwriting of the testator, that may affect even the validity of the holographic will itself. Okay? At any rate, that's one of the open questions, disputed points in succession, in testamentary succession. Now, I said earlier that 827 is merely for the convenience of the testator. 827, incorporation by reference, should never, ever be used for the purpose of incorporating testamentary provisions. Testamentary provisions must always be contained in the will itself. Hindi pwedeng nasa ka separate piece of paper and then you simply incorporate this by reference. That's not. Those will not be valid testamentary provisions. Okay. Example, one day, wala ka masyadong magawa, you decided to type on several sheets of paper testamentary provisions which you intend to include in your will. So, na-type mo na, nandiyan na yan. 10 years later, you decide to finally make your will. So, you went to your lawyer. Attorney, I want to make a will. O sige, okay. Anong provision? Sabi mo, hindi. Ito na. Na-type ko na ito 10 years ago pa. Ito ang mga provision na gusto ko. O sabi ng abogado, o sige, let's just incorporate this by reference. That's not a valid incorporation by reference. Those provisions are invalid. Because when it comes to testamentary provisions, they must be contained in the will itself. Hindi pwedeng you simply incorporate them by reference. Okay? Let's now talk about revocation of wills. The right to revoke a will is one of the basic prerogatives of a testator. A will is essentially revocable, ambulatory in character. As long as the testator lives, he can revoke his will anytime, and he does not even need any reason for revoking his will. Sabihin natin, mainit ang ulo lang niya. Pagising niya isang umaga, he got up on the wrong side of the bed. Sabi nga, he decides to revoke his will. Wala tayong kwan doon. Wala tayong keha doon. That's a valid revocation. As long as he wants to revoke his will. He does not need any good reason for revoking his will. All that is necessary is that he wills it, he intends, and he actually revokes his will. There are various ways of revoking a will. First, by implication of law. Meaning to say, by operation of law. Second, by executing another will or codicil or other writing executed as in the case of wills. Third, through a physical act of destruction coupled with intent to revoke, with animus revocandi. And the law specifies the physical acts of destruction. There are only 4. Burning, tearing, canceling, obliterating. The enumeration, according to most commentators, is exclusive. Okay. By implication of law. You find these instances scattered in the provisions of the Civil Code and of the Family Code. For example, in case of legal separation, the provisions in the will of the innocent spouse in favor of the guilty spouse are revoked by operation of law. The reverse is not true. The provisions in the will of the guilty spouse in favor of the innocent spouse are not revoked. Only the provisions in the will of the innocent spouse in favor of the guilty spouse are revoked by operation of law. Under Article 854, in case of preterition, what is revoked there? The institution of heirs. If there is preterition brought about by the omission, by the complete omission of one, some, or all of the compulsory heirs in the direct line, that results in the annulment of the institution of heirs. In case of a legacy of a credit or remission of a debt, if there is a legacy of a credit or remission of a debt, and the testator brings an action against the debtor, that results in the revocation of the legacy of credit or remission of a debt. In case of transformation, alienation, or loss of the thing, under Article 957, that results in the legacy or device becoming ineffective. In case there is unworthiness under Article 1032, the unworthy heir cannot inherit. The provisions in his favor are rendered ineffective. When both spouses contract the marriage in bad faith under Article 44 of the Family Code, or if the marriage is declared void ab initio or is annulled under Article 50 of the same Family Code. These are instances of legal provisions which operate to revoke or render ineffective certain testamentary provisions. Okay. By another will, if you execute another will expressly revoking a previous will, then that previous will is revoked. Or if there are inconsistencies between an earlier will and a subsequent will, then there is implied revocation. Okay? And then, of course, by the physical acts of destruction. Burning, tearing, canceling, obliterating. there must always be the corresponding intent to revoke. A physical act of destruction without a corresponding intention to revoke will not produce a valid revocation. If the testator one evening while looking for some kindling or something to start his the fire in his kitchen to cook his dinner, inadvertently burned his will, that's not a valid revocation. There is no intent to revoke. Conversely, not all of the intention without the corresponding physical act of destruction will produce a valid revocation. If the testator, for example, fuming mad and so angry with his heir, calls his neighbors and says, I am, as of this moment, revoking this will. Okay. Wala na ito. This is no more. This is no longer my will. My heir will not inherit under this will. Okay? I am revoking this. Okay? Dinurampa niya yung will. Okay? And then he suddenly collapses. He suffers a massive heart attack. There is no valid revocation in that case. Okay? He might have intended to revoke. But intention must always be coupled with the physical act of destruction, of burning, tearing, canceling, obliterating. If the testator, with all due solemnity, gathers his friends and neighbors and says, I am revoking this will, this is no longer a valid will, patay na ito. Ililibing natin ngayon. And he digs a hole and buries that will with all due solemnity. Is there a valid revocation? There is none. There is no physical act of destruction. Burying is not one of the acts mentioned. Although in one case decided the Supreme Court, I must hasten to add, the court considered the act of crumpling the will and throwing it as sufficient to produce a revocation. But civilists are more or less agreed. The enumeration here is really exclusive. To revoke a will by burning, you don't have to completely burn the will. Even if only the edges are burned in such a way that not a single word of the will was affected by the fire, hanggang edges lang ang nasunog, that is already considered as sufficient to revoke. Okay? When it comes to tearing, the slightest tear is sufficient as long as it is coupled with the necessary intent to revoke. Even if the tear extended only up to the margins, not a single word was affected by the tearing, that will already produce a valid revocation. Of course, instead of tearing, medyo high-tech ka, you can use a paper shredder. Revocation din yan. Or you can use a pair of scissors. Okay?